woman. Hello everyone. Welcome to this advanced training module on business aspects of commercial open source businesses. In recent years, commercial open source business models have flourished. Open source is a fast and inexpensive way to engage in a community and with that, potential customers. Open source is also popular not only at the infrastructure level, think of MongoDB or Kafka for instance, but also increasingly at the application level with applications such as Signal Matrix, Proton or Car.com. But running a commercial open source business requires an understanding of the business models that are apt for open source releases and also an understanding of when additional or alternative business models may be a better match for your business. So in this training, I provide an advanced overview of some of the key questions of running a commercial open source business. This is by no means an exhaustive overview, and we invite you to check out the additional reading material, particularly the book of Heather Meeker on building business around an open source project. The module is intended for consultants, technologists, and lawyers who advise companies on building business around open technologies and applying the principles of open innovation in the open source development and licensing model. Starting companies and investors would also find it relevant as they may wish to explore if releasing their product as open source or investing in a company that releases open source is viable. The module is organized in a train-the-trainer format to support participants not only to better understand the underlying issues of the open source business aspects, but to deliver information and tips on providing similar services to third parties. It should be complemented with domain-specific expertise of the consultant. At the end of this learning journey, you should be able to understand the main business models that exist around open technologies, explain the advantages and disadvantages of proprietary, open and mixed licensing models to your clients, and describe the basic elements of a sustainable business model that relies on open source release from day zero. Now, these are some of the topics that we're going to be covering in this module. In this video, we're only going to look at the open source strategy and innovation, including IP management, and some practical tips to starting companies. Please consult the additional materials for more information on the other topics. So, open source strategy and compliance is a topic that is essential to any company that wants to build a business around an open source project. And an intellectual property strategy of a company, I like to say, is always essential to its success. But many companies struggle to create a coherent IP strategy because intellectual property is not homogeneous. IP consists of subject matter, or assets, which are governed by different legal regimes, such as patents, copyright, trademarks, industrial designs, geographical indications, domain names, or undisclosed information such as know-how or trade secrets. Now, one common aspect is that the protection granted by these different regimes typically rests on the principle of exclusivity. That principle states that the proprietor can exclude any third party from making, using, selling, reproducing, and anything else that a third party may wish to do with respect to the subject matter at hand. A company typically has a diverse portfolio of intellectual property assets. These may range from trademarks, copyright in audiovisual works and computer software, to patents in inventions. In a typical IP portfolio, these assets are often complementary. It is therefore essential that a company builds an inventory of its IP assets before making any decisions on how to transact with them. IP strategies come in all shapes and sizes. and it is usually a good idea to retain the service of an IP professional to help devise one. Generally speaking, there are three main types of IP strategies: open, closed, and mixed, with the latter being obviously the most popular. Besides the IP strategy, more generally, a company also needs to think of its outbound licensing strategy. This is a function of its general IP strategy, and it is in fact the world-facing side of that strategy. In other words, this serves as a statement to potential customers and contributors, which sets the modalities for using, sharing, or modifying a project framework, library, or another component released by said company. Among other things, it is also considered best practice to have an open source policy. This policy must outline, among other things, the company's licensing strategy with respect to open source. Very importantly, businesses need to understand that open source policies do not shield companies from claims, because copyright infringement is tied to a strict liability regime. This means that subjective elements, such as intent, for example, do not play a role in the assessment of whether a party is liable for infringement or not. But open source policies can facilitate collaboration between different teams across multiple countries by creating a common frame of reference. That's where their utility lies. The complexity of an open source policy depends on the size of the company and the rate of involvement with open assets. Any licensing strategy is also a reasoned statement about when and how the licensing model might change. This is what we refer to as relicensing. And we could have relicensing from proprietary to open source, delayed open source publications, or relicensing from more restrictive to more permissive open source license, or from more permissive to more restrictive open source license. Typically, an open source policy must be driven by the use case and should contain at least the following elements: compliance processes, which should include inbound and outbound license compatibility, vertical license compatibility, provenance. They should also include code release and contributions information, baseline requirements for vendor contracts and other transactions, adequate and manageable business processes and internal location of roles, and review processes described in open source policies, which are typically conducted on either license by license basis or package by package basis. In some instances, companies may even prefer to set up a repository, a sandbox of sorts, of approved packages, and to prohibit, as a matter of policy, the use of packages that are not included in the sandbox. Besides the open source policy, companies should also have at least a basic license management process. This is particularly important in the age of hybrid intellectual property, which combines in a single package assets like software and data. Different types of subject matter can be integrated into a single product or service, so ensuring compatibility of the license conditions would be crucial. Now, as a rule of thumb, one pragmatic solution that provides legal certainty is, of course, to license such assemblages of code and data under a single license. So, for example, this could be the license applicable to the software, because we know how most open source software licenses work. Of course, the specifics of the situation may dictate otherwise, so please always make sure to consider the specifics of your use case. Companies must also understand that even if they present themselves as commercial open source companies, it's very likely that they would have to rely on other intellectual property protection strategies to maximize their value. Even though patents, for example, have traditionally been seen as incompatible with the open source business model, nothing could be further from the truth. There are three key questions that companies and investors should ask when managing a mixed portfolio of open source software and patent assets. First question is, what is the business purpose for patent protection? Why do we even need it? And do we need it? Second question is, what is the scope of the open source software license? The third question is, how can open source software and patents be used cooperatively? Patents and open source software are different parts of an IP portfolio. They should not be treated in a similar manner because they pursue different objectives. And when companies understand this, patents suddenly become another tool in the toolbox for increasing the value of their business offering. It's a very pragmatic and business-driven solution. Of course, there are certain risk mitigation measures that companies should follow when adopting and adjusting their IP strategy. At the very least, companies should be aware of and tread carefully in heavily patented areas. These are, for example, hardware interfacing standards or audiovisual codecs domains. Companies are also advised to join patent pooling organizations, such as the Open Invention Network for Linux-related technologies, and to adopt a contributor license agreement that grants patent rights from contributors. It's also highly recommended that companies use licenses that include explicit patent licenses, explicit patent grants. Importantly, companies should structurally separate their revenue from the IP ownership. This can be done, for instance, by incorporating an IP holding company and an operating company. Effectively, this shields the patent portfolio from any real or perceived open source issues. Of course, this could also be perceived by future investors as a risk, because the operating company might be perceived as simply a shell. Companies should also take all patent assertions very seriously and identify non-infringement scenarios, develop a non-infringement theory, work around, or even consider removal of potentially infringing assets. They should, very importantly, voice their concerns if threatened and leverage the available resources of open source communities to devise a strategy for defense. Now, our guide for starting companies and investors should be treated as a map and an initial checklist of some of the most critical issues that have to be addressed from the outset. It is by no means intended as a complete and comprehensive step-by-step guide, but rather as a resource of information, as a source of information for consultants, counsels and advisors to companies, which would be complemented by their domain-level expertise. We provide a list of best practices concerning dependencies on third-party intellectual property, record-keeping, employment agreement clauses, management of works and inventions created in the course of employment, and many others. We also provide a set of guides on choosing an appropriate licensing strategy for software, hardware, and database projects. These are, again, just some shorthand rules that always need to be complemented and interpreted in the context of a specific undertaking. By asking these questions, however, founders and investors would be better informed of the risks, but also opportunities that lie ahead. So thank you very much for listening to this brief overview of some of the key aspects of the module. Please take a look at the additional materials and reach out if you ever have a question. We look forward to seeing you again soon. Hello.